Imagine creating a music that becomes a global anthem, earning millions of dollars in royalties, but then a producer comes out of the woodwork demanding a whopping 5 billion naira in damages and claiming ownership. Welcome to the contentious lawsuit between Osinachi Joseph, also known as Sinach, and the music producer Michael Oluwele over the hit song Waymaker. Today, we are diving into the world of music law to unpack this fascinating case and also enlighten you on intellectual property rights. Hello and welcome back to Legal Essentials, where we enlighten you on matters arising from the perspective of the law. If you are new to the channel, welcome, and if you are returning, welcome back. Please do well to hit the like button and also subscribe for more knowledge about the law. This case raises important questions on intellectual property rights in music, fair compensation, ownership, and also the role of music producers in the music industry. Before we dive into this lawsuit, let's look at the impressive milestones of Waymaker. This song has reached #1 on the Billboard Christian Airplay charts for 12 weeks in a row, won Song of the Year at the 2020 Dove Awards, sold over 1 million copies worldwide, been certified platinum by the RIAA, first Nigerian gospel song to surpass 100 million views on YouTube in March 2029, been translated into 50+ languages, being a global worship anthem and most played song in the US churches, covered by over 60 gospel artists including Michael W. Smith and Bethel Music. These achievements demonstrate the song's massive commercial success and impact on the gospel music industry. Now let's examine the lawsuit. Maye, the music producer, is claiming co-ownership of Waymaker and demanding a whopping 5 billion naira in damages for alleged copyright infringement. Maye argues that his contribution as a studio engineer, recording, mixing, mastering, and creating the instrumentals for this music were indispensable. According to him, Sinach went ahead in commercially releasing this song without proper arrangements, agreements, and compensating him fairly for his performance rights. That is why he's now fighting for co-ownership of the song and share of profits. But Sinach isn't backing down. She claimed she composed, arranged, and performed Waymaker with others even before Maye was involved. She says that his job was limited to mastering the recording of the song, which he was paid 150,000 naira, approximately $300 at the time. And also, she is the sole owner of Waymaker and also owns all the copyrights. Maye is seeking several reliefs, mandating that in the absence of a written agreement between him and the defendant, all fees occurring from licensing or copyright of Waymaker should be shared between them equally as co-owners, as it describes Sinach's alleged failure to share proceeds of the song and licensing as deliberate and oppressive. And it also went on to request the court to 1. Determine an equitable division of fees as either an equal share or another division the court deems appropriate. 2. Compel the defendant to disclose all license and copyright assignments related to Waymaker, account for all accrued fees, and pay the plaintiff his due share. 3. Declare that the defendant failed in a statutory obligation to conclude written agreements with the plaintiff for his contributions to the sound recording. 4. Affirm that the plaintiff's performance rights were infringed upon. 5. Issue a perpetual injunction restraining the defendant from further reproduction, distribution, or public performance of Waymaker or any adaptations thereof. This issue highlights the complexity of music law and also the need for a clear arrangement and contract between music producers, artists, and other music stakeholders. Well, that depends if his contribution meets the threshold of originality and authorship enough to qualify him as a co-author of this composition. If Maye's instrumental works meet this threshold, he might just strike the right chord for co-authorship. For co-authorship to exist, there must be the following. 1. Intent to collaborate. Both parties must have agreed to jointly create the work either explicitly or implicitly. 2. Original and significant contribution. Contributions must add original content, and such original content must be in a fixed medium of expression, merely providing technical or ancillary support, such as editing or mixing does not qualify as co-authorship. 3. Joint work. The result must be a single unified work, not discrete sections separately authored by individuals. As co-owners of the copyright, co-authors enjoy certain rights from the Copyright Act. 1. Equal ownership. Co-authors share copyright equally unless a contract says otherwise. 2. Moral rights. This means being credited and protecting the work from misuse. 3. Exclusive rights. Each co-author can reproduce, distribute and perform the work, often transferring this right to an artist. Number 4, revenue sharing. And let's not forget revenue. Co-authors are entitled to share of the profits from the licensing of exploitation of the copyright based on their agreement. Number 5, consent for licensing. Major decisions such as licensing or assigning the copyright to third parties require mutual consent, except the right to the work has been transferred to one other. Performance rights protects the interests of individuals who perform artistic work, such as singers, musicians, or actors, under the Copyright Act of 2022. And these rights are split into 2 major categories. Number 1, moral rights. Think of this as your creative dignity. It means the right to be credited properly and also ensures your performance isn't used in a way that distorts your artistic intent. Number 2, economic rights. These rights make sure you have the power to control how your performance is being used, is being recorded, is being reproduced, broadcast, or even sold. Now, for Maye to claim this right, his contribution has to be more than just background or technical work of mixing and mastering. It must be a significant performance captured in the sound recording. But here is the twist. Formal agreement is what usually seals the deal, outlining royalties, usage permission, and credits. Without them, things can get messy. In this case, the absence of a clear contract has clearly spelled trouble. Contracts aren't just legalese, they are your safety nets to protect your interests and also your artistry. So next time you are working on something, whether it's a music production or just a venture, don't skip the paperwork. It's what will protect your rights, your peace of mind, your bag and everything in the future. At the time of this video, the case is currently unfolding at the Federal High Court in Lagos. The plaintiff, Michael Oluwole, recently took the stand to testify and defend his claims under rigorous cross-examination. Sinach legal team, however, has come out challenging Maye's claims. They have questioned the validity of his claims to co-authorship, arguing that his role was limited to providing paid technical service. The case has been adjourned to 29th and 30th of January 2025. This heated courtroom battle has all eyes fixed on its resolution. Who will the law favor? When it comes to copyright battles in the Nigerian music scene, the case of Waymaker is just a chapter in a history book full of hits and lawsuits. Can you remember the infamous feud between 2 Afrobeat icons, Two-Face and Blackface, over the hit song African Queen in 2016? Blackface claimed he's the owner of the song, while Two-Face sued him for defamation. Eventually, they reached an out-of-court settlement and Blackface agreed to drop his allegations, while Two-Face agreed to pay the royalties. Fast forward to 2018, Jugodo stayed the pot when Tekno's track faced the hit from Danfo Drivers, who accused him of sampling their classic Bolongo without their permission. Once again, things cooled off in an out-of-court settlement. So what's the lesson here? Legal battles like this highlight the importance of setting rules and stating rights before any creative project. A simple written agreement stating ownership, royalties, and licensing terms will save everybody time, money, and heartache. But what do you think? Do you think there will be a way for the supposed co-author of Waymaker? Do you think this will set new standards for collaboration in the music industry in Nigeria? Drop your thoughts in the comment section. If you found this video helpful, make sure you like, subscribe, and share for more content like this. I'm Ikemnudo, and this is Legal Essentials.